All right. I'm Joe Turner, and this is the City Manager Unfiltered Podcast, a podcast for city managers and other public sector executives. It is the most influential local government podcast in America, and if there was Exhibit A to illustrate that point, it would be the anti-defamation lawsuit filed by James Freed against the ICMA. If you will recall, the ICMA publicly censured James Freed back in June or July of 2022, and he filed a lawsuit shortly after that, a few months later, and it's been going on for about 2 years. We are coming up on the finality, the conclusion of it. It's coming to a head. I think this is going to be wrapped up really soon, and I'm going to unpack that a little bit more here in a minute. Now, this case has really picked up a lot of steam in the last couple weeks, and I want to unpack a little bit the timeline here and walk you through it because there's been some developments if you haven't been paying close attention. So let me bring you up to speed. Back on the afternoon of Thursday, September 5th, James Freed sent out an email with a statement as well as attaching a 20-page court filing with it. Now, I have not talked about this, but I will share what I know about the situation, and that is James and the ICMA were scheduled to have a court hearing on Monday, September 16th. That's 2 days ago. That court hearing involved the ICMA filing some statements or some documents, and then the Freed's team filing some documents, okay? Freed released the documents from his legal team that they had filed as part of this hearing that was supposed to occur. This is supposed to be the last sort of hurrah before they go to trial, last sort of pre-conference settlement negotiation attempt or whatnot. I don't know the legal jargon, guys, so forgive me. But this was going to be the last hurrah. It was a formality, and then they were going to trial because the ICMA had shown no willingness to budge and settle this case to meet the terms that James had demanded. Okay? So in this email that James sent out on the 5th, he dropped a couple of bombshells. One is he stated that the ICMA had already made an offer to settle the case for a large dollar amount, but that he turned them down. And he turned them down because he said he was going to refuse to settle unless the ICMA retracted the censure and apologized. Frankly, this email kind of caught me off guard because James has kept a pretty low profile throughout this whole situation, right? I mean, he came on my podcast, yes, a year ago, and he did a couple interviews for some local papers out there in Michigan or what have you. But as far as the ICMA case, he's kept a pretty low profile. So he comes out on the 5th. He sends out this blast email to, I don't know who exactly, I'm sure all his peers and colleagues in Michigan, and puts out that statement as well as the court filing. Now, the court filing is shocking because it has references to multiple depositions provided by or given under oath by ICMA staff and executive board members. This includes ICMA CEO Mark Ott, the ethics director, Martha Perego at the time, the ethics advisor, Jessica Cowles, and also Molly Maynor, who is the chair of the Committee on Professional Conduct and also on the executive board. Those 4 depositions are cited numerous times in this court filing, and man, it doesn't look good for the ICMA. In short, the ICMA and multiple members and the depositions admit that they didn't investigate the case thoroughly and that they did not follow the rules or processes for ethics investigations. I mean, basically, they didn't follow their own rules. It's not a good look. It's terrible. So I announced Friday morning in my first post of the day that I was going to release this letter, this email statement, and this court filing and talk about it or later on that day at noon, Friday at noon, right? So I release it. I telegraphed that I'm releasing this information at noon. I release it at noon, and then about 15 minutes after I release it, the ICMA finally makes a statement for the very first time mentioning James Freed and this lawsuit. I was shocked when I saw this. Someone tipped me off to it. I had to go scramble over to the ICMA page because I couldn't believe it. And lo and behold, the ICMA issued a statement that was dishonest. It was just factually incorrect and gaslighted the members, right? And I'm going to unpack that here in a minute. But the big thing is I was shocked. They'd actually posted about the James Freed lawsuit, and it just blew me away because, one, they hadn't commented at all whatsoever. They've been silent this entire time, so they finally buckled and caved in and had to respond. We finally got to them here. This podcast, when I say it's the most influential podcast in local government, that's what I mean. The ICMA finally had to respond because I have been throwing too many shots and they were going unanswered. So they responded on LinkedIn. Now, fast forward to Monday. This is interesting because two things happened on Monday. One, the ICMA put up an article on their website that was very similar to the LinkedIn post, and it was authored or written by Jason Grant, the Director of Advocacy, and it was similar in the context that it was gaslighting the members. It was repeating some dishonest, inaccurate statements. It also said that Jason Grant also argued that public censures are not punitive. Like, what? What are you talking about? What universe are you living in where you think that public censures are not punitive? Also that day, James Freed is having a city manager's luncheon, an annual luncheon, and at the end of this luncheon, he decides to speak for 20 minutes to his employees and explain to them what's about to happen. That is that he's going to go to trial against the ICMA. They're going to hear about it, and so he wanted to bring them up to speed. I'm going to play that 20-minute clip here in a minute because I do not have him as a guest here today. Now, when the ICMA put out the statement on their website on Monday the 9th, I read it, and to me, it immediately signaled that they were capitulating and getting ready to settle. And I posted on LinkedIn about it. I'll read that last paragraph again after we get through James Freed's comments. But I say that because it's important to understand the context here. James Freed's attorneys were supposed to have a hearing with the ICMA's attorneys on Monday the 16th. That hearing did not happen. James was going to interview with me on Tuesday the 17th, the day after that hearing, and we were going to unpack the case even further. You got to remember, this is the ICMA annual conference is coming up next week, and I wanted to use the weeks leading up to the conference, similar to how I did last year, to co-opt it and leverage it and maximize the exposure for the James Freed lawsuit by talking about it, bringing James on the podcast, so forth and so on. Now, Freed contacted me and said, Joe, I can't come on the podcast. I'm like, why? Well, you know the conference is next week. I'm planning on having you on the show. I need to have you on the show. I got a podcast to do. What's the deal? Because I can't get into it, but I can't come on the show. I'm a little bit frustrated, to be honest, because I wanted to have him on the show. I thought it was going to be an absolute banger and get a lot of downloads. You got to remember my podcast that I did with James last year is my all-time greatest performing episode. It's got unbelievable downloads. I think it was like over 5,000 downloads. Look, I got an IQ north of 2. I got to try to put things together. The ICMA puts out a statement on Monday the 9th, basically announcing that they're going to capitulate. And, actually, I'm going to read that right now, just so you know what I'm talking about. Here's what the last paragraph of that article written by Jason Grant says. Quote, as the case progresses, the ICMA Executive Board, with guidance from legal counsel, will determine how to move forward in the best interest of the association. We must consider financial implications of defending the case, probability of potential outcomes, and most importantly, the effect upon our ability to enforce the code of ethics as a professional organization. Listen, guys, I don't think it takes a rocket scientist to figure out that they're announcing they're getting ready to settle. They can't afford to go to trial and lose. They can't afford to have the depositions come out. They can't afford to have all the evidence come out. They know they're going to be exposed. It's terrible. I've stated time and time again, this will not go to trial because they cannot afford to go to trial. It will be too damaging. And right there in that paragraph, that's the code. That's the cheat code right there. They're telling you, we're tapping out. I think that's what's going on. So because I can't have James Freed on the show here and he won't tell me what's going on, I'm going to play for you what he put out there, okay? Because I got to tell you, it doesn't make sense for James to ramp up and be all of a sudden come out of hibernation and start talking about his case, right? With the email on the 5th, the luncheon with his employees on the 9th, right? Planning on being on this podcast. It doesn't make sense for him to start ramping it up and all of a sudden just stop for no reason, okay? But anyway, here is his statement. It's about 20 minutes long, and when we get out of that statement, I'm going to give you some additional thoughts and break down the ICMA LinkedIn post and some other stuff, okay?
Well, before we go today, I want to take an opportunity to share with you something that's been going on in my life for about 2 years that I think you should be aware of. Things I haven't talked about publicly, but I need to now. And it affects all of you, and you'll find out when I tell this story. But there's some days I have to decide how I'm going to speak to an audience, right? So there's some days I will speak to you as my friends and colleagues. There are other days I will address you as the employees of the city of Port Huron. Today I'm going to address you as my fellow citizens, okay? I want to share with you a story. I want to brief you on this. So in about a month, when you begin reading about this, and this becomes in the public eye, you will know the story behind it. And when I speak, you will know my reasons. When I act, you will know my heart. And I want to tell you this. So in March 2020, Jesse and I were on a cruise to the Bahamas. Well, on that cruise ship, I began getting media briefings about this COVID-19 virus, the coronavirus, which was emerging around the world. I remember one night, I was having a cocktail with an 80-year-old lady named Dottie, because we do Royal Caribbean, it's an older crowd. And Dottie just told me she got back from an Indochina cruise. And I was literally like, oh God. I was like, geez, I just read about that, you know? So I was a little fearful. But at that time, no one knew much about it. So I came back to Port Huron, and within 3 weeks, the world had come to a stop. We had shut down. We were one of the first municipalities in the state of Michigan to close down. I remember when I met with my department heads, I said, this coronavirus thing, like, you know, people are saying we should shut down operations. So I'm thinking like the 2-week pause, the 14-day pause. Well, no one else in municipal government, anywhere in the county or anywhere in the state, had shut down yet. And so my thought was, one, I could delay closing city operations, and the pandemic comes to fruition and hundreds of my employees die, or out of abundance of caution, I could be the first to close down city operations and go remote work from home. And I told my department heads I would rather look like an idiot than inadvertently kill my employees, because we just didn't know. We didn't know what was going on. So we closed down city operations, and we all bugged out, and that was something special. We bugged out for about, I think it was 30 days. And then we began doing COVID protocols to return into work, and that was incredibly expensive. We spent, I would say, I think it was $100,000 on microbial spraying. We'd go through at night and fog all the facilities, fog the police trucks, fog the fire patrol cars. If you go to my desk within my office, the enamel on my desk has actually been destroyed from the microbial fogging, destroying the varnish on the desk. We bought thousands and thousands of masks. We brought hand sanitizers. I remember people were dumping off tubs of hand sanitizer because you couldn't find it at the time. It was like the black market. One night I was on the phone with a Chinese broker to buy like $100,000 worth of K95 masks and ship them here. I wasn't sure it was legit or not. I thought, I'm going to wire $100,000 and be out of it. I mean, you just didn't know what you were dealing with. But we all experienced the fear, the unknown, and the panic of what we were going to do. So fast forward about a year later, I'd say, thanks to President Trump and Operation Warp Speed, vaccines became available. Vaccines became available. Now, if you remember, vaccines were hard to find. You couldn't get vaccines. In fact, when the first vaccines came out, only first responders qualified: police and fire, EMS, healthcare workers. The general public couldn't get them. And so we were the first city to negotiate with Kroger, and Kroger actually did the first of its kind on-site vaccine clinic within City Hall. We actually did 136 doses of the vaccine on that day. It was very hard to get, very proud of that. Remember, it was a 2-dose vaccine. I'm a big believer in the vaccine. My wife and I both decided to be vaccinated, and I sat for the first round, and I did a photo op, if you all remember, me taking the vaccine. And I thank the American healthcare workers and science industry for developing such a vaccine to protect us from the COVID vaccine. If you remember, at the time, they believed that if you received the vaccine, you couldn't get COVID and you couldn't transmit COVID, which we now know is false. That was false. So we got the vaccines, we did several rounds of vaccinations, we promoted them throughout the city, and then word was getting, people were getting frustrated essentially. You got about 50 to 60% of the country that is taking the vaccines, and then there was a large vaccine hesitation. People who would not get the vaccine, which was an experimental drug on experimental approval from the FDA. And so rumblings out of Washington were that maybe a vaccine mandate was going to come down the line. So sure enough, in November, I believe it was, the President of the United States did a press conference. And he announced that OSHA had been directed to develop a vaccine mandate or test rule, administrative regulation. It was a vaccine mandate or test. Essentially, you had to force your employees to get a vaccine or implement a weekly testing protocol to keep your employees safe. The caveat was this is for all employers with 99 employees or more. 99 employees or more. Well, the city of Port Huron, we are one of Michigan's largest core communities. We actually have about 544 employees, if you count all our seasonals and part-timers. 544 employees. Which means we were going to have to make the decision. If the OSHA ETS rule went into effect, we would have to decide. Now, what's a little bit unique about the city of Port Huron is that all administrative, per our voter-approved charter, all rules and regulations governing employees and operations are the responsibility of the city manager. So as the city manager of Port Huron, I had the legal authority, and not only that, the legal obligation to make this decision for our operations of whether or not we were going to impose a vaccine mandate. I did not have the luxury, like other managers across the state, then punting that to the legislative body, just your decision to make. So I had to make that decision. We knew we had a little bit of time until it ramped up, right? Until we actually had to do it. I think the implementation time was going to be January. So we had a month or so before the hard deadline to make your decision. So I began hearing from employees. I began hearing from the general public. I talked to you in the elevators. You and I have had conversations. I remember walking the hallways. So are you going to force us to get the jab? Are you going to give us the jab? I knew employees that were going to resign and leave our operations if I forced them to get a vaccine mandate. Specifically, police and fire, which already there was a shortage of police officers and firefighters in the state of Michigan. I knew employees that had called smaller municipalities who were less than 100 employees and said, hey, you're hiring a police officer. Can I transfer over my MERS time? Can I transfer over? Already making plans, should I implement a vaccine mandate, that they were going to leave. And so my concern was, if I did implement a vaccine mandate, how would I manage to run the fire and police departments and our operations with key people resigning for whatever was it, religious beliefs or personal beliefs or their own body and their own healthcare choices? So, whenever we take the oath of office, we all remember taking the oath of office for our positions. When we think about the enemy at the gates, I always envision the movie The Patriot, and where Mel Gibson is running across the field and just stabs the guy with the British with the American flag to save America. That's pretty much what I envisioned when I was signing up for. Like, you know, so help me God, if the British come, I got this. We're gonna protect the country and the Constitution. I didn't know the threat to liberty in the Constitution would come from within. I did not realize that. So my moment was not on a glorious battlefield carrying a flag. My moment was in a very quiet moment within my office where I had to make a decision. I had to decide whether or not I was going to force a vaccine mandate on my employees or whether I would implement a weekly testing option, which I will explain is a little bit more complicated than it sounds. My fellow citizens, if I'm ever forced to confront the options of whether or not to choose the Constitution and the protection of individual liberties, or implement a totalitarian, unconstitutional vaccine mandate, I will always choose the Constitution and the protection of individual liberties every time, so help me God. So the following day, I have to inform the staff of the decision that I made. So I'm going to read you an email that I sent to city staff informing them of my decision, which I was obligated to make and obligated to inform you of. And the email is this: City staff, I know there's been significant news and information floating around regarding the OSHA ETS and the forthcoming mandate for employers with 100 or more employees. Municipalities do not fall under the jurisdiction of OSHA. However, we do fall under the jurisdiction of MyOSHA. And they will need to promulgate additional rules that they seek to include us in any future mandate. Hear me now. I will never enforce a vaccine mandate upon my employees. I took an oath in office to uphold the Constitution when I took this position. I will uphold my oath, come what may. I earnestly believe that one of the many federal judges across this country will issue an injunction soon, and I also believe that the U.S. Supreme Court will soundly reject the overreach of the administrative state. Laws are made by duly elected U.S. Congress, Senate, and they are signed by the President of the United States, not unelected bureaucrats. I hope I have made my position on this issue for you clear. Have a great weekend. James. What I meant by that email was I was referring to the major questions doctrine, meaning the courts have long upheld that the administrative state does not have the ability to implement vast sweeping rules for all the American population. It's called the major questions. When there are major questions regarding the American people, it must be done through the duly elected legislative body and signed by the executive. Same where the city manager of Port Huron cannot write an ordinance for the city of Port Huron. I do not have the authority. The duly elected mayor and council must implement vast sweeping laws because the power is always held to the people and their elected officials. So now that I chose not to implement a vaccine mandate, I had to begin implementing a testing mandate, which means every week we would have to have a testing protocol where the employees who chose not to be vaccinated would have to be tested. Now, when you go home and you take an at-home COVID test and just look at it and toss it in the trash, that's one thing. But when you bring your snot to work, it becomes a little more complicated. When you take a biohazard, a swab, it is clinical in nature. There's bloodborne pathogen rules, and there's custody of all the testing. There's a whole protocol. So what I did is I drafted a OSHA-compliant testing policy, which is a draft testing policy, and then I went out and I purchased thousands and thousands of COVID testing kits to be able to facilitate the testing. And then I had to get a third-party clinical group that would actually administer the test. They would actually stand up a testing clinic that you could stop into, get your test. So I had implemented the testing policy, I had purchased the testing kits, and I had signed a contract with a third-party clinical firm to administer the test to all the employees on a weekly basis. That is the action that I took. I was surprised when a few weeks later, I received a letter from my professional association called the International City and County Management Association, the ICMA. They sent me a letter and said, hey, we're conducting an ethics investigation into you for possible violating our code of ethics. And I said, well, what have I possibly done? And they said, well, this email you sent to your employees. And I go, email about what? They go, the vaccine mandate. I go, what about it? They go, well, we think you're being unlawful. You're telling your staff you're not going to implement the law. And I said, no. You got it all wrong. The law was I had the choice between a vaccine mandate and a testing policy. I chose the testing policy. So my legal team wrote an 11-page briefing in response and sent it to them and said, hey, here's all the facts. Here's a copy of the city charter. Here's a copy of our receipts from the testing. Here's a copy of our contract. Here's a copy of our testing protocol. Here's everything. Which I was surprised to find out, to receive another letter informing me that my professional association was going to publicly censure me for a Tenet 3 violation, which is breach of public trust. A Tenet 3 violation, a public censure for Tenet 3 is a career ender. No city manager has ever been publicly censured for Tenet 3 who hasn't been fired, resigned and disgraced, convicted, prosecuted, or jailed. It's one of the above. So they were treating me as if I had violated a federal law and I should be in jail. So we wrote them all the response. I said, hey, you can't do this. We wrote them, the mayor and council wrote them a letter saying you have this wrong. He has the authority to do this. This is within the law. They ignored all of it. And they issued a press release statewide and to all the Detroit media that publicly censured me for preemptively declaring to violate a specific law or policy when it's the manager's duty to do so. And that I lacked honesty and I lacked integrity. They put it all out there. The first phone call I got was from Jackie at the Times-Herald. James, what law did you break? I go, there was no law, Jackie. I didn't say I was going to violate the law. Well, that's what they wrote. I go, I get what they wrote. I tried clarifying it. I walked into the gas station the next morning to get my coffee, and there was the front page of the Times-Herald with my picture. And it said, city manager censured, dishonesty, unlawful, lacks integrity. That moment in Speedway was the most humiliating moment in my life. I was so embarrassed. I was so embarrassed to see my picture with that words. After 17 years of being a city manager, I was so humiliated. My wife called me from Walmart in tears a couple hours later and says, I'm at Walmart. Have you seen the Times-Herald? And I go, yes. She goes, why would they do this? There was no law. I said, I don't know. I don't know. Your perspective and outlook on life changes when you have kids. I never really knew that until I had 2 little girls. I have Lucy and Annie to think about now. That's my number one priority. And what makes me think about when I saw that newspaper is thinking, Lucy and Annie are not always going to be 6, and they're not always going to be 2. Soon they're going to be 13 and 16 and 17. And they're going to start to wonder what kind of father they have. They want to know more about their dad. Say something should happen to me and I die. What kind of father do they have? I cannot have my little girls read that their father was unlawful, lacked integrity, and was dishonest when that was patently, provenly false information. I sent a retraction notice, my legal team did, to the ICMA. We said, you have got this all wrong. We will give you an opportunity to retract and correct your statement. They refused to do so. They refused to do so. I was left with the worst decision I ever had to make. I mean, I've never had to make something like this. I've never sued anyone in my life. Don't want to be litigious, you know. But I have a public censure, as if I'm the last person in Michigan who was publicly censured was a guy who was embezzling, corrupting contracts. He's still in federal prison, I believe. Was the last person to be publicly censured under Tenet 3. So they wouldn't retract it, and so to protect my reputation, to redeem my reputation, and to protect my family and my ability to provide for my family. I hope to be the city manager here for a long time, but the truth is, things change. I could get walked out the door. Maybe I want to progress in my career, but I can't have that on my record, a false statement like that. So I filed a defamation and civil conspiracy lawsuit against the International City Managers and County Management Association because they refused to retract what was provenly false. For the last 2 years, they have fought very hard to get this case dismissed. They tried to get it moved to a federal court. That didn't work. They tried to get it dismissed at the state courts. That didn't work. They cannot get rid of this trial. This case. We are going to trial next month in October. The trial will begin. During the process of discovery, we uncovered exactly what we already knew. Sworn statements called interrogatories and depositions. The people who organized the censure against me had no idea that the OSHA ETS provided a testing option. They had no idea that I had the charter authority to make such a decision. In fact, they believed that when MyOSHA filed that false citation on us that we won, they believed that was MyOSHA citing me for violating a vaccine mandate. They had no idea. They testified that they didn't even review my appeal. They never did any investigation into the veracity of the statements I was making. They never even looked in to say for a moment, did we get it wrong? What they did was literally the legal definition of reckless disregard for the facts. More concerning, our discovery proved what we already feared was that this was politically motivated hatchet job witch hunt. So, we are going to bring them to Michigan next month and put them in front of a jury, and we'll have the jury render a verdict. But I wanted to tell you what was going on, because it's going to be hard when you see what's this story about a trial on a vaccine mandate, because there's no vaccine mandate. But I want you to know that when I meant come what may, I meant three things when I said come what may in my email. One is there was a lot of pressure on those who were not getting vaccinated. If you remember, they were calling it the pandemic of the unvaccinated. And those who weren't getting vaccinated were selfish. And I knew that if I didn't implement a vaccine mandate, there would be some employees who were upset with me for that. And I understand that. But at the same time, I knew I had to protect individual freedom and the right to choose. The second thing I meant by come what may was cost. The cheapest, most cost-effective thing I could have done was implement a vaccine mandate, because it's just get vaccinated or you're unemployed. Now I had to buy thousands of dollars in test kits. I had to pay thousands of dollars of a third-party firm to facilitate the testing, draft all this, and staff time to come do it. There's a tremendous cost to it. The third thing I meant by come what may is I knew that when I sent that email, I was making a decision that should no exemption be allowed, should no testing option is allowed, I would resign before I took those kind of civil liberties away from my employees. I would resign. After that email, the day after that email, ironically, a federal judge issued an injunction. And then just a few weeks later, the Supreme Court soundly struck down the OSHA ETS as unconstitutional, as we all knew it was. As we all knew it was. So there's your briefing on what's going to happen. Today I want to talk to Mark Ott, Jessica, and Martha, and the ICMA Board of Directors. I am James Freed. I'm the city manager of Port Huron. And on behalf of my family, my wife Jessie, Annie, and Lucy, we will see you next month here in Port Huron, and so will a jury of the American people. My fellow citizens, now we get to go forward, grateful for our freedom, faithful to our cause, and confident in the greatest nation the world has ever seen. I want to say God bless all of you. God bless the great state of Michigan, and may God bless the United States of America. Thank you.
Now, that was the audio version only of James Freed's statements, but this was actually from a video recording. And in that recording, at the very end, James looks directly into the camera and speaks to Mark Ott, Jessica Cowles, and Martha Perego. So he's as serious as a shotgun blast to the chest. He's all business. Did you also notice that in that statement, Freed once again reiterated how the ICMA staff and executive board members had no clue what the facts were for the case? They did not investigate. They didn't know what was going on. They didn't want to know, because this got in the way of them going after James Freed. He talked about this being a political and personal vendetta. He talked about the evidence, right, the depositions. He said that basically the evidence shows, and they'll point it out at trial, that this was a political and personal vendetta against him by the ICMA staff and executive board members. They can't let this come out, guys. They can't let it come out. Now, I'm going to read you some passages from the court filing that James Freed put out there on the 5th, the 20-page document, and it's going to be linked in the show notes. On page 4, it's talking about Jessica Cowles' aggressive pursuit of James Freed during the very first ethics investigation, right, over the Perego letter, when he exposed Martha Perego's Twitter handle and how she was engaging in partisan political activity. It says that after that investigation, and I dissect this entire thing on citymanagernews.com. Again, I will link to it in the show notes where I just break it down piece by piece. It says that although the ethics committee initially moved to discipline plaintiff at Ms. Cowles' recommendation over this trumped-up charge, cooler heads prevailed and the plaintiff was ultimately cleared 4.5 months later. Okay? The only reason James was cleared is because he recorded that phone call. Otherwise, he would have been punished and probably censured in that BS trumped-up investigation about whether or not he violated Martha Perego's confidentiality when he never even filed an ethics complaint against her, when she was not even eligible to be investigated under Tenet 7 because she was not in service. The whole thing was trumped up and bogus, right? Cowles knew that Freed did not file a complaint against Perego, therefore he could not have violated the confidentiality, but instead she was still going to recommend punishment because they had this axe to grind against him. Then it talks about the second ethics investigation of James Freed. If you recall, somebody complained that he had been taking pictures with Republican politicians. Now, the complaint only included pictures of him with Republican politicians at non-political events and did not include the pictures of him with Democrat politicians at non-political events. He's a city manager. He takes pictures with elected officials, Republican and Democrat. This was somehow turned into an ethics investigation that lasted 9 months. And from page 5 of this filing, it talks about how it was sent back to the MME for a fact-finding committee to investigate, and they looked at it and said, there's nothing to see here. It says the MME fact-finding committee ultimately found no violations and questioned why there was even an investigation, stating it was not, quote, not aware of any broad prohibition of being photographed with anyone at the time they are a candidate for elected office, end quote. It goes on to further say, quote, each member of the FFC, the fact-finding committee, agrees that we would certainly pose for a similar photograph with any of the elected officials pictured, end quote. And therefore, Freed was cleared. How does that last 9 months, guys? How does that investigation into Freed over pictures with political candidates not at political events mount to a 9-month investigation? Now, fast forward to the third and final ethics investigation into Freed, the one where they finally publicly censured him, right? It says on page 7, Mr. Ott determined that Ms. Perego should not be involved in the investigation due to plaintiff's prior concern regarding her. And it cites the deposition testimony. Quote, she should not be involved in an investigation or leading it. Contrary to Mr. Ott's directive and unknown to him, Ms. Perego played an active role and believed she had no such limit. It refers to Perego's deposition on page 25-26. This is prior to the start of the investigation. And despite the requirement that a member be presumed innocent, Ms. Perego expressed bias against the plaintiff and told Ms. Cowles, quote, this guy is really unbelievable, end quote. Exhibit 25, Perego deposition, page 32-35. Mr. Ott testified that this was, quote, an unfortunate comment, one that she shouldn't have made, end quote. That's Ott's own words on page 54 of his deposition. Then it goes on to talk about how Perego writes to Cowles about Freed, quote, someone that unprofessional doesn't need to be part of the ICMA, end quote. That's Exhibit 26. Mr. Ott testified that this type of bias was the exact reason he did not want Ms. Perego involved in the investigation. Ott deposition, page 57. On page 9 of the filing, it states that, unfortunately, Ms. Cowles chose not to review the veracity of plaintiff's claims and testified that she did absolutely no investigation into the facts. This refers to Cowles' deposition, volume 2, page 36. It also says that Ms. Cowles, Ms. Perego, and CPC Chair Ms. Molly Maynor were unaware that the ETS did not mandate employees to have a vaccine mandate, were unaware that the ETS did not apply to city employees unless and until it was adopted by MIOSHA, were unaware that MIOSHA had not implemented a vaccine mandate, and were unaware, even though the plaintiff had told them, that in January 2022, that Supreme Court struck down the ETS as unconstitutional. The ICMA was also unaware that the policy decision for city employees under the Port Huron City Charter and ordinances was a decision left to the city manager, not his city council. So his email was a simple reflection of his decision. It goes on to state that when Mr. Ott later found out that his subordinates did no investigation, he testified that he had expected them to do an investigation, quote, as they always do, end quote. Ott, deposition, page 45. It goes on to say, moreover, under ICMA rules, if the facts are in dispute or if the investigators do not have the necessary information, the ICMA is required to send the matter to MME for a fact-finding hearing. This is on Exhibit 9, Perego deposition, page 70-71. Instead, the ICMA, at Ms. Cowles' recommendation, decided not to send the matter to a fact-finding hearing per Cowles' deposition on Volume 2, page 77-78. On page 10, it says both Mr. Ott and Ms. Perego agreed that this decision violated ICMA's rules and was very concerning. From Ott, quote, of course I'm concerned when the rules aren't followed, end quote. Perego said on page 49 of her deposition, quote, it makes me nervous when we don't follow the rules of procedure, end quote. Ms. Maynor agreed that there were important missing facts the CPC needed, but the CPC did no investigation. That's according to her deposition on pages 46-47 and 56 and 69. And it goes on and on. I'm probably boring you guys at this point because it's probably hard to follow without reading the document and I'm trying to quote it and what have you. But this goes on and on. It's a terrible look for the ICMA. They cannot go to trial, guys. They cannot go to trial. They are going to lose bigly. Now, one of the things I find frustrating about this case is I know that there's a pervasive sentiment amongst you all, some of the ICMA loyalists and the members who say, okay, Joe, we hear what you're saying about James Freed. We've heard his side of the story. What's the ICMA side of the story? What are their bombshells? What evidence do they have? What haven't they shared with us yet? What's in James Freed's depositions? What has he said under oath that's damaging to his case? Well, let's unpack that for a second. So the court filing that James Freed put out was essentially a response to a court filing that was submitted by the ICMA attorneys, the one for the September 16th hearing, okay? What's that's called is a defendant's motion for summary disposition. Basically, it's like a last-ditch effort to get it thrown out or something like that. I'm not a legal scholar, guys, okay? But what I want you to know, and I'm going to post a link to this in the show notes and post it over at citymanagernews.com. Let me share a fact with you about the 20-page court filing submitted by the ICMA attorneys, and I think you're going to find this a little bit unbelievable. There isn't one mention, not one single mention of the James Freed deposition anywhere as evidence in their filing. Let me repeat that. Whereas James Freed, in his court filings, have cited ICMA staff and executive board members numerous times in his court filing, the ICMA legal team did not cite James Freed deposition one time. In fact, they didn't cite any deposition given by any plaintiff witness, including James Freed. They did not cite one instance in their court filing. Their entire court filing is a dissection of the ins and outs of what defamation is or isn't. There is no disputing any of the facts that James Freed has put out there in his statement in that court filing, from the depositions, or at the city manager's luncheon. Nothing. The ICMA's legal team, and again, I'm going to link to it, says that essentially their censure was merely their statement of an opinion, and because it's an opinion, it's not defamation. I kid you not, that's literally the summary. In fact, I'm going to read you a couple portions from that filing, that summary for disposition, right? I'm going to read that to you right here, right now. On page 10 in the second paragraph, it reads, quote, Freed claims the press release, newsletter, and letter to Port Huron's mayor announcing the public censure are defamatory. They are not. All they communicate is the board's opinion and decision that Freed's conduct violated ICMA's code of ethics, which is not defamatory as a statement of opinion. On page 11, it reads, the press release does not say that Freed himself is unethical. The press release merely says that his conduct, in the board's opinion, violated the code of ethics. As a result, this cannot be a defamatory statement. On page 13, it says the ICMA did not make any objectively false statement of fact against Freed. It says the board simply made a judgment call about whether Freed's conduct violated the code of ethics. That subjective determination is not something that can be objectively proven true or false, and is not defamatory under the law. Can you believe that? This is the ICMA's attorneys saying this, guys. All right. Further on page 13, it says, Freed cannot prove actual malice. Because Freed is a public figure, a qualified privilege applies, and he must prove with clear and convincing evidence that the defendants made false statements with actual malice, meaning they made the statements with knowledge of the statement's falsity or through reckless disregard of the truth. Guys, they admitted they didn't even investigate. Molly Maynor, in her deposition, states that they knew they didn't have all the facts and they still didn't investigate further. They didn't follow their own rules of procedure. They didn't follow the process. In the deposition given by Jessica Cowles, Freed, in my very first interview, said that her staff report to the executive board regarding the very first ethics investigation, not the one they censured them on, right? Going back to the Martha Perego letter, that her staff report misrepresented what actually occurred between them on that phone call that was recorded. Remember that 20-some minute phone call that I played in that second episode of the podcast where James was having that back and forth with Jessica, and he was having a very polite conversation with her about his confusion about why he was being investigated when he never filed the complaint against Martha, to even know she was an ICMA member subject to ethics code tenets. Jessica Cowles misrepresented that conversation in a staff report. Basically, she lied. That's my understanding, is that she lied about what happened. But yet we're supposed to somehow believe there wasn't actual malice, there wasn't a personal vendetta, there wasn't a political vendetta. Give me a break. And I'm going to read one last passage from the ICMA court filing. On page 14, it says, quote, as an initial point, Freed is likely to make the argument that certain people at ICMA had a personal vendetta against him, and that's what led to the public censure. End quote. No shit, Sherlock. You think? Moving on, it says, quote, that's wrong factually for a number of reasons, but defendants are limited in the number of pages they have to make their arguments for summary disposition. So rather than spend pages and pages showing why Freed's claim is wrong based on the facts, they will focus on the legal issue. Freed's argument is irrelevant. The point here is fairly simple. The actual malice standard, quote, does not require a showing of ill will or animosity towards the plaintiff. The standard focuses on something entirely different, whether the defendants doubted that the statements were true when they made them. If Freed spends any time saying that certain people at ICMA dislike him, not only is that untrue, but it is irrelevant to the actual malice analysis. So they're saying it's untrue that people at the ICMA dislike him. We're talking about the same folks, namely Pamela Antill and Bill Fraser, right, who said that he looks like a douchebag and they want to punch him in the face. We're talking about Molly Maynor, the chair of the CPC, who had never interacted with James Freed, getting into histrionics about supposedly how he is going to be a violent person and therefore they need to have security, treating him like he's a dangerous threat. On top of that, she initiates the entire conversation at the appeal hearing by starting out with the completely inflammatory and dishonest statement that Freed had, quote unquote, past ethical issues when he had never been convicted or found guilty of any ethics violation whatsoever. You have the emails between Perego and Cowles where Perego says, can you believe this guy? And we know that Jessica was pissed off that Freed recorded the conversation and exposed the fact that she lied in her staff report to the CPC. But we're supposed to somehow believe that there's no malice, that nobody has any dislike for James Freed, and even if they did have dislike, and there's no actual malice, and therefore it's irrelevant. Give me a break, ICMA attorney. We're getting a little long, so I'm going to pack it up. I was going to dissect the LinkedIn post, but I'm not going to get to it today in this podcast. I will just tell you, I will link to it. It's over at citymanagernews.com, and it's just total gaslighting. And I will tell you one part. I will mention one part about that LinkedIn post, though, that caught my attention and really sticks in my craw. Okay? Let me read this to you. The first paragraph of this post, first, it shows you the power of this podcast and my platform and for exposing this lawsuit that James had filed against the ICMA. But they decide to bring me in and make this a personal thing, whoever wrote this statement. I'll read it. It's the very first paragraph. It reads as follows. The ICMA has received a number of messages asking about the James Freed lawsuit against ICMA. As our members know from their own experiences facing lawsuits from disgruntled residents, sound legal advice discourages commenting on the case. However, remaining as open and transparent as possible is important, particularly if a party or non-party in the lawsuit chooses to spread misinformation and disinformation on the matter, as is the case here. Well, I'm that non-party, obviously. And I want you to remember that line of choosing to spread misinformation and disinformation, because I'm willing to bet a lot of money that this case does not go to trial, that they are going to settle because they can't afford to go to court and lose. It'll be too damaging. And then we're going to come back and talk about who's spreading misinformation and disinformation. Because when the ICMA says in this statement that they went through a thorough, thoughtful, and professional decision-making process and that it was a rigorous investigation, these are their words, not mine. That is dishonest and untrue. It's patently untrue, and it's going to be exposed at court. Mark my words. That's going to be a wrap for this episode. I'm Joe Turner, host of the City Manager Unfiltered podcast, a podcast for city managers and public sector executives. It is the most influential local government podcast in America. If you've not hit that follow or subscribe button on your platform of choice, please do so today. If you've not left a rating or review on your platform of choice, please do so today. It would really mean a lot to me. I put a lot of work into this, and catch you on the next show.